The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everybody. Welcome to the Littman Krooks webinar on changes to the New York State Medicaid program. My name is Laura Brancato. I'm an attorney with the office. I'm just going to give everybody a couple extra minutes to join. It looks like we have a few attendees who are signing in now. So we'll begin in just about 2 minutes. And as a matter of housekeeping, while we're waiting, you have a message capability in your GoToWebinar screen. If you should have any questions during the broadcast, please feel free to type those questions and I will be able to see them, and we'll try to get to as many questions as possible before we reach the hour mark here. Okay, I think we're going to get started. So again, my name is Laura Brancato. I'm an attorney with the law firm of Littman Krooks, and today's webinar program is going to focus on the recent changes to the New York State Medicaid program. We're going to talk about the legislative changes that have recently been enacted, the date that they will become effective. And again, if you have questions during the broadcast, please feel free to type them into the question or chat function on your GoToWebinar screen. And at the end of the presentation, I will certainly try to get to as many questions as possible. So let's get started. So for those of you who are not familiar with the New York State Medicaid program, I thought it would be helpful to start with a brief Medicaid overview. So as many of you may know, Medicaid is the only provider of long-term care insurance for those clients who do not hold private insurance. And what I mean when I say that is that the Medicare insurance that most senior citizens carry is a medical-based insurance. It covers hospitalization and doctor's appointments. But your Medicare insurance will never cover the cost of long-term care, especially care at home. It will provide a couple of weeks of rehabilitative care should you have an injury, but it's really never going to cover long-term care. So that means that individuals who might need care at home or in a facility will either have had to have purchased a long-term care policy at some point, earlier in their lives, or they will be responsible for paying privately for the cost of their care. So Medicaid in New York State is a provider of long-term care insurance for clients who have not purchased private insurance. New York State Medicaid covers care at home or care in a long-term care facility, a nursing home, rehabilitative care, in some limited cases, assisted living. And just so we are aware of what we're focusing on today, the rules for care in a facility, a nursing home care, are not the subject of this presentation. The regulations relating to qualifying for nursing home care have remained unchanged. We will not be focusing on care in a nursing home. If you should have questions related to Medicaid eligibility in a nursing home, we're happy to answer those questions for you at a later time. Medicaid home care is the overwhelming choice of our clients and clients across the state. And the care at home is meant to meet a medical need. We'll talk a little bit more about that as we go along. What qualifications do you need to meet in order to receive care at home? But the reason that these changes the legislature are enacting are so significant is that most individuals would prefer to stay home with care at home. And the changes that were recently implemented significantly impact access to the Medicaid home care program. And this is going to be problematic for many of our clients. At this moment in time, Medicaid home care can meet a 24-hour need. 24 hours can be provided by live-in care or even by two different nurses called a split shift, 2 12-hour shifts in a day, up to 7 days a week. So the New York State home care program is an exceptionally generous Medicaid coverage, and it substantially reduces the outlay of costs related to home care. So what will change? What are we thinking is going to be the impetus of the change that the legislature just enacted? The recently enacted changes target Medicaid home care program, as I said a bit ago, and does that specifically with the implementation of a look-back period. So some of you may be familiar with the concept of the look-back period. That's a period during which Medicaid can review your finances and look for any transfers of assets. Prior to the new Medicaid laws, there was no look-back period for home care. Most of our nursing home clients have been through the process of having 5 years of their documents reviewed for a look-back period, but that had not been the case for home care. These changes will focus on some significant look-back period requirements now in the home care program. We're also seeing an implementation of stricter care standards in order to qualify for Medicaid home care, and we'll go through those care standards later on. We're also seeing an implementation of care review for current Medicaid enrollees who have 12 hours a day or more in home care. So this is really important for our clients who are already enrolled in the Medicaid home care program and whose loved ones may receive care in excess of 12 hours a day. It seems like the legislature wants to review those cases to assure whether those clients are being cared for safely at home, and our concern is whether there will be a push to move those individuals into facilities. And the last piece that's of significant concern is the potential for review of all currently enrolled participants during recertification. And what that means is that all of our clients who currently receive Medicaid home care every year or every 6 months, depending on the level of care they receive, they must participate in a process called recertification, where Medicaid reviews financial documents and assures that the Medicaid applicant is still meeting all the financial criteria for enrollment. It's unclear in the way the law is currently drafted whether or not all patients in the recertification over the next 12 months will be subject to this new look-back period. And we're going to have to wait for further clarification from the legislature on that. So why now? Why are these what are the concerns? Why has this law come to light? So New York State is trying to address a huge budget shortfall within the Medicaid program, approximately $6 billion shortfall, just Medicaid alone. So it's important to note that these changes were in the works prior to the current state of emergency, prior to any COVID-related health expenditures. The governor crafted the Medicaid redesign team early this year in an effort to address the ballooning spending that's going on within the home care program. So that's happening for a number of reasons, not the least of which is the number of people who are in need of care at home, whether that's due to increases in the diagnosis of Alzheimer's or dementia, the fact that people are living longer. There's a number of factors, but the government is trying, New York State government is trying to address this increase in care need. So this is an attempt to also control the staggering increase in the cost of care plans and home attendance. So unlike the nursing home where costs are fixed and where Medicaid pays a fixed rate for every patient in the facility, currently in New York State, there are variable costs related to home care. So the state is trying to set a more strict budget on who gets care and how much they get. And we anticipate that this means it will become increasingly difficult to qualify not only financially, but from a care perspective as well. And we'll talk about that too. And we want to put, the aim was to put New York in line with states across the country that have limitations on home care. By far, it's been readily reported that New York is the most generous state with regard to home care. And so this is an attempt to limit access to the home care program to keep costs down. So let's talk about, in order to understand the changes, let's talk about what the current enrollment criteria look like, and then we can compare that to what the new criteria will be. So again, we're talking only about Medicaid home care in this scenario. Again, it's been historically easy to qualify for New York Medicaid because there has been no look-back period. And what that means, we'll go through some examples, is that if you're holding assets over the Medicaid resource threshold, which is about $15,000, you could transfer the funds within a month and the following month be ready to apply for Medicaid home care and be financially eligible for the program. And you could then qualify for up to care up to 24 hours a day, 7 days a week. There was also a ready access to a program that's called the Consumer Directed Program, commonly referred to as CDPAP. So let's talk about that for a second, because that's a really important piece of the puzzle. Medicaid home care in New York State can be provided in a number of ways, but the two most popular ways are either through a managed long-term care provider, which is a home care agency. You may be familiar with some of the bigger home care agencies in your neighborhood. Down here in Westchester, we see a lot of Family Health Plus or Premier Home Care. Agencies like that are managed through what are called managed long-term care companies. And so you call that agency, they work internally to set you up with a home care attendant. They assess how many hours you might need and then set the program up. Now, the other extremely popular way that individuals are cared for at home is through something called the CDPAP program, Consumer Directed Program. And this is a program which allows a patient to hire their own home attendant. And that can be a family member, anybody but your spouse. It can be your children, your grandchildren, a niece or a nephew. It could be your neighbor. It could be somebody that you had been working with prior to applying for the Medicaid Home Care program, someone you were paying privately, and now you're seeking some assistance from the state in paying for that care. So this is a really important program for those of us who might be looking for a very specific type of home attendant, someone who speaks a certain language, someone who has a certain familiarity with the patient, and especially important for those of us in the state who live in a less populated area. So down here in Westchester and White Plains, it's a pretty dense population, lots of access to public transportation. So home attendants have ways to get to and from clients' homes. That's not the case further upstate. And so consumer directed program for those clients is very important because it allows those who don't have ready access to a managed long-term care company to hire anybody who might be available. And the way to qualify to be an aide under the CDPAP program up to this point has been pretty straightforward. It does not require any type of training. A background check is required and a few other things, but overall, very easy to qualify to work as an employee under the consumer directed program. We're going to see some substantial changes to that program now, and we'll talk about those. So as of October 1st, 2020, the new home care regulations will take effect. I want to take this second to note one thing about the October 1st effective date. The legislature was clear to include that effective date could be pushed back if the state of emergency in New York had not yet been lifted or if we were still experiencing some COVID-related issues. So right now, as written, the statute indicates October 1st, but we could see some flexibility in that date. So as of October 1st, there will be a 30-month, 2.5-year look-back period imposed on any home care application submitted October 1st forward. This specifically applies to non-spousal cases, and we'll get into an example in a minute, and I'll show you what I mean by that. We also are seeing in the new regulations pretty much an overhaul of the consumer-directed program. Again, that's the program where you hire your own home attendant, where you pick somebody of your own choosing. We're going to see some changes there with more stringent qualification criteria. The person who hires their own aide is going to need to have a significant medical need at home, and they're going to need an independent health assessment to qualify, which had not been the case prior, which is not the case now and won't be until October 1st. And we will see under the new regulations, as I mentioned earlier, a review of current enrollees who are accessing 12 or more hours of care a day. So I think it's easiest when we're talking about Medicaid to look at examples. So let's talk about examples and see how things will change from now through September 30th of 2020 and what it will look like in October. So let's assume for purposes of this example that John and Jane are a married couple. Jane needs assistance at home. So when I say assistance, I mean specifically the following. She has difficulty walking safely in her house. She's unsafe getting to and from a seated position, and she needs assistance toileting. So those three things that I mentioned are important to keep in mind. Those are what we call the activities of daily living. Walking is otherwise known to Medicaid as ambulating. Getting to and from a seated position is otherwise known as transferring. And needing assistance in the bathroom is commonly referred to as toileting. Those are the three main activities of daily living that Medicaid is trying to meet when they provide home care services. If you remember early on, I said your care at home must be medical necessity. And this is the way that we determine Medicaid necessity. So it's not just that you want companionship at home. It's not just housekeeping services. You have to rise to a certain level of care need in order to qualify for Medicaid care at home. And we can address more specific questions about that offline or an email or in a consultation. So let's assume Jane needs help with all three of her activities of daily living. She's applying for the Medicaid Home Care program effective April 1st of 2020. She had assets in excess of the $15,000 threshold. She had those assets last month in March. In March, she transferred all of the assets that would make her ineligible to John, and we applied for her April 1st of 2020. The result in that case would be a Medicaid approval, assuming that she had a care need according to Medicaid. The result would be that she would have Medicaid approval. And in this example, I'm assuming what's called the spousal refusal. For those of you who may not be familiar with the terminology, spousal refusal is a planning tool that exists in New York, where one spouse can transfer everything to another and be eligible immediately. And that would be true for home care or care in a nursing home level. And that was actually a huge consideration in the budget. The governor was actually considering eliminating the spousal refusal opportunity, which would have been a very difficult challenge for us, but that it survived. So spousal refusal continues on. Jane can transfer her assets to her spouse. In March, John could sign a paper called the spousal refusal, refusing to make those assets available for Jane, and Jane can immediately become eligible for Medicaid the following month under the current law. So now let's look at a second example under the current law. Example number 2, assume that Jane and John divorced. Maybe they divorced in 2019 at some point. Now it's the spring of 2020. She needs the same level of assistance. She needs help with all three activities of daily living. She applies for the Medicaid Home Care program looking for an effective date of April 1st of 2020. In March, she had more than the limit of $15,000 or so she transferred those assets to her daughter in March of 2020, okay? Not to a spouse because she doesn't have one. So she transferred assets to her daughter in March of 2020 and applies for an April 1st eligibility date. The result under the current law is a Medicaid approval. Under the current law, she could transfer assets in March and be eligible the very next month. So now let's go to example 3 and see where the changes take effect. So take that same scenario with Jane as a single person with the same care needs. She needs help with all three activities of daily living. Now let's move her forward. Let's say she procrastinated all summer. She wasn't sure she wanted to apply for the home care program. She wasn't sure how she would, whether or not she wanted a stranger in her home, which is something we hear a lot about. And she thought about it all summer, and in the fall determined that it was a good idea. So let's assume that in preparation for that application, she transferred assets to her daughter in March of 2020, just as she did in example 2. But now we try to apply for her to receive care as of November 1st, 2020. The result here will be much different. She will be denied Medicaid home care, and there will be an imposition of a 30-month look-back period. So because Jane transferred assets to make herself eligible, within 2.5 years prior to her application date, she will receive a denial for Medicaid home care services with the imposition of what's called a penalty period. Penalty period is best explained by noting that when you transfer assets, Medicaid will total up all the assets that you've transferred and divide that by the regional rate of care, and that's determined by the county where you live. So rates upstate are much lower than rates downstate. Out on Long Island, rates tend to be higher. New York City, the rates are substantially higher. So basically, it's a mathematical equation that will determine how many months you will be ineligible for Medicaid coverage, which means that you will have to fund coverage privately during the penalty period. The only way to really move away from a penalty period is to have the assets transferred back to you. So let's say that Jane, in this example, transferred assets to her daughter in March of $100,000. If her daughter could return those assets to her prior to the application, there would be no penalty period. But as most of us know, when we give a gift to children or to other relatives and we don't qualify it and say, hold it because I might need it back, oftentimes that money is not available to be returned. Maybe a house was purchased with that money or a vacation. So in that case, a penalty period would apply, and there would be a substantial period of time during which Jane would have to fund home care on her own before Medicaid could pick her up. Now, in example number 3, it's important to note, if Jane had still been married, if Jane and John had stuck together, and she made the transfer to John in March of 2020 and applied in November of 2020, remember, she would be approved under this example because she can transfer assets to her spouse and be eligible for Medicaid. This transfer between husbands and wives is ignored for Medicaid purposes. There are a number of other exceptions to the Medicaid rule regarding transfers. Other than a spouse, there are a few other individuals who can receive assets. And I'll just give you a few. If you have specific questions about your family structure, we're happy to answer those for you. But ultimately, the list of exclusionary transfers remains unchanged. So you could transfer assets to a disabled child. You could transfer assets, for example, to a supplemental needs trust for an individual under the age of 65. Those exclusions persevere and they remain under the new statute, but very few people actually fit into those categories. The large majority of people applying for home care are either giving money to a spouse or to a child or a grandchild or someone else. So here is where we are the most concerned because this is a substantial shift in the current rules. So as I mentioned earlier, there are other changes that will take effect in October relating to the home care program. So as we talked about before, the CDPAP program will become much more stringent. If you want to hire your own aide under the CDPAP program, you will need to have medical needs with all 3 activities of daily living: ambulating, toileting, and transferring. And this had not been the case and currently is not the case. When a care assessment is done, when either an agency comes in or your doctor writes a note regarding your care needs, we don't require, at this point, Medicaid does not require total need with all 3 activities of daily living. Often we will have someone who's unsteady on their feet, who might need help getting up from a seated position, but can otherwise, once they're up on their feet, walk unassisted or toilet without trouble, and we could still get home care hours for those individuals. Now it seems like the legislature really wants to narrow the window on who should be able to qualify for care, specifically under the CDPAP program. The change here seems to be targeting the substantial increase in the number of people who applied for the CDPAP program and potential for abuse or misuse of that program. So we had some instances of someone hiring their grandchild, saying their grandchild was there 8 hours a day, but the grandchild may never have shown up, or and still getting paid by the Medicaid program. So the state is trying to address the misuse of the program, and like most instances where there's misuse, it ends up inadvertently affecting the people who had been using the program properly. So there is one exception here for patients with cognitive impairment, and this is a really important exception. So we are seeing an explosion in the number of cases of individuals with cognitive impairment, either due to Alzheimer's or dementia, and care at home is by far the preferred way of handling those cases, since there generally is not another overarching medical need to be in a facility. So being home is preferable. Under the CDPAP program, if you have a cognitive impairment, you will only need to have assistance with 1 activity of daily living, not all 3. So if you need help walking, toileting, or transferring, you'll only need to demonstrate 1 need in that area, which is a big help because it's often difficult to qualify for home care with just a cognitive impairment as it is. So needing help with all 3 activities of daily living might have made it near impossible to qualify with a cognitive impairment. So there is a really important exception that was written into that law. Under the new CDPAP program, the care assessment will also be performed by an independent physician under contract with the Department of Health. That had not been the case prior. Prior, your personal physician would write a letter and your care would be prescribed, and whoever you hired as your personal attendant would come in and provide those hours. Now, in an attempt to limit abuse or misuse of the program or overuse of the program, a care assessment will be performed by an independent doctor under contract with the state. So what we can assume here, knowing what we know already about the Medicaid program, is that this will not be an easy or quick process. Anything that involves review by the state generally takes a decent period of time. So our concern here will be whether there will be even more delays in getting a home attendant approved and paid for at home under the new CDPAP program. And not only will the care assessment be performed by an independent physician, but the hours must then be approved by the independent assessor, which is a second level of review, meaning even after the independent physician from the Department of Health says mom needs 8 hours a day, 7 days a week, that recommendation will then go to an independent assessor who will review it and determine whether or not those hours are justified. And our thought is that at that level, the independent assessor will try to further reduce whatever hours the Department of Health was willing to approve. And they will be using something called a task-based assessment tool. Now, the task-based assessment tool is already being used by managed long-term care providers. And what that means is that when an assessment is done, there's a rating scale. A nurse or other qualified person would appear at the home, meet the applicant, and visually observe or hear from caretakers how a person ambulates, transfers toilets, and does many other things. How do they dress? Can they dress themselves? Can they bathe themselves? Can they feed themselves? And all of those tasks are given a rating scale. And at the end, the number is added up, and let's say you get an 84. An 84 might equate to 8 hours of care a day. And so that's a much more regulated way to provide home care hours that would be more consistent across the board. So Medicaid is looking at implementing a task-based assessment tool for hours under the CDPAP program to keep it in line with how care is assessed by a managed long-term care company. It's worth noting here that there is great value in speaking with an elder law attorney about these issues. And one of the greatest values is that most people don't know. You don't have to accept the hours assigned to you by a managed long-term care provider or now under the new CDPAP program by the independent assessor. There is an inherent appeal process within the Medicaid program, and an experienced elder law attorney will know how to access that appellate process for you. In certain circumstances, it might be a fair hearing. In other circumstances, it's a request for review. It really depends on who's providing your care. And an experienced elder law attorney will be able to guide you in determining whether or not you want to challenge the hours assigned by the independent assessor. And oftentimes, when challenged, the administrative law judge, who's an independent party, will find in favor of the applicant that the hours assigned by the assessor or by the managed long-term care company are simply not adequate. Most managed long-term care providers or other providers are guessing that most clients don't know that there might be an appellate process. And so we're urging you, if you have specific questions about care, if your parent or your loved one is already receiving Medicaid home care and their needs are increasing, you don't just have to stick with what was originally given to you. There's always an opportunity to ask for a reassessment, and we urge you and encourage you to reach out for someone in our office so we can guide you through that process. So what's interesting about the way the legislature handled this, this change is that there are a lot of areas where further clarification will be necessary. Now, remember, though this process was in the works at the start of the year, it certainly was culminating right in the middle of the most urgent time during this most recent health crisis. So while Governor Cuomo was on and still remains on TV every single day addressing some other more urgent concerns, this process was happening behind the scenes. And so getting this bill together and getting provisions in there with the lobbying efforts of the Bar Association and others, there seems to be some areas where we will wait for further clarification before October 1st. One of those areas is whether or not the use of a pooled income trust will still be allowed. Now, it's somewhat of a complicated concept, and if you already enrolled in the Medicaid Home Care program, you probably know what a pooled income trust is. So when we qualify for Medicaid, when we're guiding clients to qualification, there are actually two financial areas you need to qualify. The first is that your resources, bank accounts that you hold, are at or below approximately $15,000. The second necessity is that you have income at or below approximately $865. Most New Yorkers have income that exceeds that number because the cost of care in New York is higher, salaries are higher, Social Security and pension payouts are higher than $865. So New York has allowed applicants to use the pooled income trust to stay eligible for the Medicaid Home Care program. The legislature didn't provide any information on whether transfers to that kind of trust would trigger a look-back period or a penalty period. So we're going to have to wait to hear more about that in the coming months. We will also wait to hear about what the new tool for home care assessment looks like under the CDPAP program. Will it be substantially similar to what managed long-term care providers use? Will it be a completely new form? Who will create it? What input will they seek? That all remains to be seen. We're also concerned about reduction in care hours. As I mentioned, for those clients who receive 12 hours or more of care who are going to specifically have this review process undertaken on their behalf, will there be a push toward nursing home care, which seems to be in the works, but we can't yet say. And so certainly we urge any client who is attending the webinar at this time, should you receive any communication from the home care agency that's caring for your loved one, please don't wait. Reach out for an elder law attorney, reach out for us so we can help guide you through the process. If it seems like they want to conduct a review and potentially reduce hours, we certainly want to know about it. As a community of elder law attorneys, we're actively discussing these issues because they disproportionately impact the population who needs the most care. And so we always want to take advantage of every appellate right we might have if the care company is proposing a reduction. And as we discussed earlier, how will recertification be handled? That would be problematic for every single person already on the program. Will any transfers in the last 2.5 years make you ineligible for a program that you already have become eligible for? We're hoping the answer to that is no, but certainly we will have to keep looking for more information. And it's important to note here that if you don't already receive the Littman Krooks newsletter via email, please go to our website and sign up. We regularly send out updates and information related to these changes, and we will certainly be keeping an eye on it and sending out updated information on a regular basis. So whenever we do a webinar, we always try to get to the question of who needs to act. Based on the information I've given you today, who needs to act? So let's go through that a little bit. Everyone should assure they have proper estate planning documents in place at this time. For obvious reasons, we're all thinking about whether we have our affairs in order at this point in history, right? This has just been a historically difficult and challenging time, and everybody should assure they have proper estate planning documents in place. Healthcare proxy, a will, other advanced directives like a power of attorney, etc. And you can go to our website and access. We've done a number of presentations relating to these types of documents, and we're happy to help you there. But other than your basic estate planning documents, asset protection should be addressed by every client who has already prepared estate planning documents and those who are doing it for the first time. And what I mean by that is simply doing a will, power of attorney, healthcare proxy, though that's vital, that's not what we would consider to be enhanced estate planning or asset protection. Asset protection takes the next step to discuss, should certain assets be held in a trust? Should certain transfers be effectuated now or in the future or ever? Should I invest in an annuity or other types of products that could be Medicaid protection? How are my IRAs or 401ks treated under the Medicaid laws? And this is essential because if you should need care at the home care level, and certainly at an institutional level at a nursing home, you will need to have moved your assets more than 2.5 years in home care or 5 years in nursing home care, more than that time period before applying for Medicaid. Waiting until you need care is too late. So who needs to act? Anybody who might be concerned about how they hold their assets and whether their assets are protected. So who else? Anyone who currently needs any assistance at home. Anyone who's been thinking in the back of their mind that they might reach out for a home care agency to supplement care at home for a loved one. Now is the time to do that. At the current moment, the laws remain unchanged. And it seems that from what the guidance we've received, applications processed before October 1st will not be subjected to the look-back period. So if you apply, if you've been thinking about applying, or if it was something that you had contemplated at some point, now is the time. Now is the time to speak to an experienced elder law attorney, the attorneys at Littman Krooks who do Medicaid applications on a daily basis for our clients. And anyone who's currently receiving Medicaid home care who has in excess of 12 hours a day, I would suggest speaking with an attorney just to make sure that your care hours are preserved and whatever care arrangement you have set up is left undisturbed. Okay. So how can I protect myself or my loved one? Act now if you intend to rely on the home care program for assistance. Meet with an elder law attorney to review your plan and identify the proper way to protect your assets. And last but not least, know that there are emergency planning tools that can be utilized if all else fails or you just haven't transferred. So what I mean by saying that is, much like in the institutional care Medicaid application, there are emergency planning tools that the state gives us to use to minimize the penalty period. It will not eliminate the penalty period, but it will minimize the penalty period. We never recommend that clients wait until the situation is an emergency, of course, but we want to make sure that if the worst case scenario happens, somebody has a sudden illness or an onset of a disability and can't remain safely at home and they haven't planned, that does not preclude you from taking protective measures. There are certainly measures we can take even in an emergency circumstance. We do it regularly to help preserve some of the assets and make sure that the care is implemented as soon as financially possible and guide you through that process. So we certainly wouldn't want you to wait even if you feel that you missed out on a deadline or an opportunity. So at this point, I see a number of questions coming in, and I'm going to start. I'll read the question out and we'll see what we have here. So if a person is enrolled in the Medicaid Home and Community-Based Waiver Program, are they going to do a look back on that program? So that again depends. If you're currently enrolled in Medicaid in the waiver program, we assume that your program will remain unchanged. Again, that's one of the pieces that we will wait to hear more clarification about how recertifications are going to be treated. If you're already in a waiver program, and for those who don't know, waiver program is a program making those younger than 65 eligible for Medicaid services. If you are already in a waiver program, we would assume that your program would remain unchanged, but certainly stay tuned for information about how those recertifications will be treated. Okay, next question. What happens to the home that the proposed Medicaid person owns with a spouse? Okay, this is a two-part question, so I'll stop there. So the house, that's a good question. The house as an asset for Medicaid purposes in the current law is considered an exempt resource if it has a fair market value less than $875,000. So an individual can own a home and still apply for the Medicaid home care program, and in certain circumstances, even apply for the nursing home program while owning a home. Certainly, depending on your circumstance, we may recommend that one spouse transfer their interest in the home to the other and have the well spouse refuse, but that's not always required. The new law, it's unclear whether the home the treatment will remain the same But for purposes of home care Medicaid, the rules have always been different relating to the home. So we don't expect that the home will be pulled into any kind of Medicaid home care calculation at this time. But of course, as the rules get clarified, it could change. So the second part of this question is also if a spouse not applying for Medicaid owns another home, what happens to that home? Okay, so this is an important thing to note. If you are an individual who is applying for Medicaid, say we're go back to the Jane and John example. Say Jane is the Medicaid applicant, and she and John jointly own the home they live in and a vacation place out on the east end of Long Island. You cannot own two pieces of property and be eligible for the Medicaid home care program. You cannot hold property outside the state and be eligible for New York State Medicaid program. So Jane would have to not have an interest in the second piece of property. So if her spouse has his name solely on that home and he signs the spousal refusal, he could certainly try to protect the house. There are rules about spousal contribution, and that's a subject for a different webinar. If you have questions about that, we can certainly answer them. But Medicaid can and does see contributions from spouses based on the refusal law. You can refuse to make the assets available initially, but that doesn't extinguish the right of Medicaid to come back in seeking contribution later on. So we try to use the refusal only when it's absolutely necessary to protect our clients from future litigation. If you have questions about that, we're certainly more than happy to answer those. The next question here. So if someone transfers assets to a relative and then applies for community Medicaid prior to October 2020, the 2.5-year look back does not apply. The answer to that question at this time is yes. So if Jane transfers assets to her daughter in April of 2020 and applies in May of 2020, then her application prior to the October 1st enacting of the new law should be read under the old rules, what we will call the old rules, also known as the current rules. Under the current rules, the transfers to a relative would be fine. If Jane transfers those assets in April 2020 and waits until November 2020 to apply, she will get caught in the look-back period. So it's really about the application date. It's not only about the transfer date, but it's also about your date of application. We expect to see a huge increase in the number of applications that will be going in the next 6 months or so. This is another reason to act as soon as possible. The delay in getting this program implemented and getting all of this straightened out with the legislature will probably cause a huge delay in the provision of home care services. So if you know it's something you've considered and you think your loved one or yourself has concerns now and think you could qualify now from a care perspective, now is the time to consider it, to speak with an attorney and consider it. The next question. Okay, that's the same. Okay, question. I'm currently enrolled in the CDPAP program, 15 hours a day, 7 days a week. Completely dependent, unmarried, 52 years old, and no funds. What can I do? Okay, so if you have questions about your CDPAP enrollment, one of the ways you can handle it is to go to the Department of Health website, and there will soon be, I was scrolling through it last night, there are a number of resources available there to guide you. There are also a number of not-for-profit organizations. This particular question is from someone who is stating here that they may not have funds to hire an attorney. New York Legal Assistance Group is a not-for-profit organization that helps individuals who need to access the home care program. So you might try their website if you find that you're getting a reduction in your home care hours. We don't expect it to be anything you get notification of, let's say in the next 2 weeks, but certainly over the next 6 months as we get closer to the October 1 inaction date, you will probably see communication regarding your CDPAP program. So we would encourage you to reach out to a group like New York Legal Assistance. Question here, only spouse is on the second property, not the Medicaid applicant. Okay, so that seems to be a follow-up to the question I read earlier. So if that's the case and your spouse signs a spousal refusal, then the applicant should be eligible for Medicaid. But remember, you must disclose the, even though you sign the spousal refusal, you must still provide the financial records to Medicaid for review. So Medicaid will know that the spouse has a second piece of property. In that case, you increase your chances for some type of spousal recovery the more assets you have while applying for the Medicaid program. Question: what is the best way to transfer an IRA to a trust for a disabled adult when there are multiple siblings, but not everyone is disabled? Okay, so this is a little bit off topic, but I'll spend a minute talking about it. IRAs should not be transferred to a trust because if you're talking about Medicaid eligibility, IRAs and 401ks are exempt resources. What that means is that the total value of the IRA is not included in the $15,000 limitation. So, you know, you should seek more independent advice from someone at our firm or another firm relating to whether or not the IRA as an exempt resource still allows you to be eligible for Medicaid. Even though Medicaid disregards the total value of the account, the income stream coming out of the IRA in the form of a required minimum distribution will be counted on the income side of the equation. So we urge you to reach out to an attorney at Littman Krooks to discuss that in further detail. You don't want to transfer an IRA to a trust. In most cases, you can't transfer an IRA to a trust. And you certainly don't want to put an individually held IRA into a trust with multiple beneficiaries. That's really not a great idea. Okay. Let's see, it scrolled. Do you work with families on Long Island? Yes. So what's interesting about this time is that the governor has signed a few emergency orders that are allowing us to not only meet with clients virtually, but to sign documents and witness documents via virtual execution, virtual client meetings. So though there have been many difficulties during this time, Littman Krooks has really been able to provide all the services we had been providing in person to our clients virtually. It's been going really well. We're doing virtual document executions almost every day, meeting with clients for the first time, either through a conference call, a Zoom chat, a Skype chat, FaceTime, any way you can envision it, we have done it, and we've done it successfully. So we're happy to work with clients in the tri-state area, including Long Island, and you can go to the website or call our phone number to make an appointment for a virtual consultation. And most of the time, Medicaid applications can be done virtually because we just need copies of certain bank and financial records, and we could do most of that over email. Okay, great. So I'll give it one more minute for any other questions that anyone might have. Okay. It doesn't seem like, oh, okay, we have one more coming in. Oh, okay, here we go. What happens to the Social Security and pensions of the applicant if they go to a nursing home and her spouse is on pensions and SSA? Okay, so this is a somewhat long question, and it really applies to nursing home care. So I will answer this briefly. So basically, when a person goes into an institutional care setting, like a nursing home, all of their income, pensions, and Social Security, and any investment income, et cetera, is due to the nursing home in full, save for a $50 holdback every month. And that's a complicated concept. It seems here this question relates to a spouse who's in the community. We call a community spouse. So they have a spouse in a nursing facility and they remain home and rely on that income. So I think that that's a question that would be better answered individually, because it does involve something called spousal maintenance, and that really depends on the income of the spouse who remains in the community. So if you have any questions about that, you can email the administrator of this webinar. Her name is Kian, and the email address is K like kite, M like Mary, A, M like Mary, A, KMAMA at littmankrooks.com. And with any follow-up questions that you might have, or you can call the office and schedule a consultation with one of our experienced elder law attorneys, because that question really, we need a little bit more information to answer that question completely. It says here, one more question, what will the proposed changes do to immediate needs? That's a really good question. So briefly, there is a program in New York State under the Homecare umbrella that deals with immediate need clients. Traditionally, home care applications can take 60, 90, even 120 days to be processed and the care assessment done. So for clients who can afford to wait, who can either pay privately or don't need immediate care right away, that delay is not significant. But for some of our clients who have an immediate need, that delay is impossible to bridge. So the state devised what's called an immediate need application to try to get services in for the client within the first 7 days. This usually applies when a person is coming out of a rehab facility or a hospital back into their home and has a change in what their needs might be, and we need some immediate care to make sure that they can stay safely at home during their recovery. How this will affect immediate need has not been made clear as yet. Our biggest hope would be that immediate need would be preserved and that certain individuals who have immediate need would still be able to get the care within that same 7-day timeline. Remember, immediate need is only an option if you are already financially eligible for the Medicaid program. If you do not meet the criteria for financial eligibility, if you are, let's say, stuck in the look-back period because you transferred assets in the spring of 2020 and then applied in November of 2020, you are not eligible for immediate need because you are not eligible for the program. So we're hoping that the timeline for immediate need stays the same, even though the processing of home care applications will become much more difficult and time consuming. But remember, you cannot get immediate need if you don't already meet the Medicaid criteria. Okay. So again, if you have any further questions, our website, littmankrooks.com, is a wealth of information regarding all of the topics we discussed today. We've been putting out numerous blogs, podcasts. Our past webinars are all accessible on our website or on our YouTube platform, other platforms that we host. So we might, if you need more further information, we're happy to provide it to you through that format. Okay, another question coming in. What happens to all the individuals with autism that have this service? Okay, so there are, as I discussed earlier, there are a number of individuals through the Medicaid waiver program, those who are not yet 65. The changes here do not seem to apply to the waiver programs like OPWDD or the open door programs. So it seems to be more based on new applicants who are applying for the home care program specifically. Most individuals with autism are not accessing the home care program. They may be accessing a different program through their OPWDD waiver, and we don't see any specific reference to that in the new law. But certainly if that changes, our experienced attorneys in our state planning division and in our education division would be putting out information about that if we see anything coming down the pipeline relating to those services. There's another question here. Any special requirements for transfer of assets, for example, to a daughter? That's a really good question. So as experienced elder law attorneys, part of our job is to advise on if you plan to transfer assets to a child, what are the preferable ways to do that? Would a Medicaid asset protection trust be the best way? Oftentimes the answer is absolutely yes. And so you want to meet with an elder law attorney to determine what is the best method of transferring assets to a child. Remember, when you transfer assets outright to an individual, you're giving them ownership over those assets. Should they be sued as a result of an accident, or should they get divorced? Any assets that are in their name individually could be considered part of their own estate. And so we want to make sure that there is a protected way to move assets. In some cases, especially in smaller amounts, transfers outright to children are not the worst idea. But in other cases, especially in light of the new look-back period, we want to make sure the assets are preserved for you, for your benefit, for your lifetime, even if you have to divest yourself of them to qualify for the program. So you definitely want to meet with somebody to determine, in your particular case, what is the best way to transfer the assets. Another question here. Yes, another question about autism and the CDPAP program. Again, it's not clear whether the new CDPAP regulations will apply to currently enrolled Medicaid applicants. That is definitely something I had on that slide about what's coming in the future, needing more clarification. We will be waiting for further clarification from the legislature on how they intend to treat currently enrolled applicants. And certainly we will pass that information along to our clients via the Littman Krooks newsletter or in future podcasts, webinars, Zoom chats. If you have further questions about your individual circumstance, please visit our website or call our number and make an appointment to speak with somebody. Okay, I'll answer one more question here. The question is, would my father be ineligible if he withdraws more than the required minimum distribution from an IRA? So again, you know, in this particular circumstance, we would need a little bit more information about the IRA distribution and whether or not your father is already receiving Medicaid home care. Income distributions tend not to make clients ineligible, but they do tend to make the income deposit to the pool trust or other spend down measure, they tend to increase the requirement for a spend down. So if it says here that there might be a disabled adult living in the home, if he draws more than the required minimum distribution and transfers that amount of money to a disabled individual, it will likely be protected, but it's hard to say without a little bit more information. So I would caution you against using that one way or the other. There's a little bit more information we would need regarding what other income the person has and what program they're accessing, if any, at this time. Okay, great. Well, it's been my pleasure to share the last hour with everybody here. Our wishes to all of our clients and all of our listeners who may be impacted by this current pandemic. And we're certainly here for you in any way, virtually, through the telephone, email. We remain open and ready to answer your questions and support you in any way possible. And we look forward to working with you in the future. Have a great day, everyone.